There's an interesting defense that is by statute, but and it exists in most states in one form or the other, but it's called the statute of repose. It looks on the surface like a statute of limitations defense, but it's more than that. Let's say you are an architect and you design a building. And obviously the building has to be designed in such a way that it's structurally sound and meets all the codes and the building codes and so forth. Well, the question becomes, how long should the architect be held accountable for any sort of problem with the building? Okay, in other words, well, what if the building is still occupied 50 years later, 75 years later? Should the architect still be held liable? Well, that's a big issue, because think about your insurance premiums. If you build a building and you're going to be held responsible for 50 years, you're going to pay a lot of insurance premium. So basically, states began to enact statutes of repose. In other words, there came a time where responsibility would shift from the architect and engineer and builder to the owner of the building. And, I've seen them, is for example, 15 years, that sort of thing. But what's different between that and a statute of limitations in a big way is a statute of limitations begins running from the time of the incident leading to injury, whereas a statute of repose begins when the construction of the building is complete. So that means you could be injured. You could be injured, and the statute of repose ran before you even had the incident. So that's a big difference. Statutes of repose, this is one of the common ones, the architects and engineers statutes of repose with respect to building. Now we get into kind of a technical area. There are defenses that sometimes aren't called defenses. Basically they are, but because of technical reasons, they're not called an affirmative defense. For the purposes of our discussion, I'm going to treat them like defenses. Sometimes they're called matters in avoidance and this sort of thing. But just to let you know that it's a little bit technical difference, and it probably for the average person doesn't mean anything. Imagine this. You're driving along on a 4-lane roadway. Let's say it's a city street, but it's 4 lanes. And you're in the right lane, minding your own business. And all of a sudden, the car next to you swerves because someone has come from the oncoming lane right into the second lane where this car is next to you. Bang, this car moves to avoid the head-on collision and strikes your vehicle, and it causes you injury. Well, you didn't do anything wrong. And the person who hit you was the one next to you. Well, sometimes that person won't be held liable. Try explaining that to a client. I mean, they look at you incredulously, like, what kind of lawyer are you, Well, I'm the kind that has to bring bad news sometimes. They have a rule of non-liability, if you will, called sudden emergency. And sudden emergency involves somebody who has to act suddenly because of some human agency that creates danger for them. The car coming out of the oncoming lane right into your lane would be an example. Under those circumstances, if the person who swerved into you was deemed to have acted reasonably, given the pending emergency, They may be found not liable. Yeah. Now they have a similar rule of non-liability called unavoidable accident. Now, unavoidable accident is a sudden emergency situation, but it involves a non-human agency. Let's say that a tree falls on this same roadway. You're in the right-hand lane. You see this tree falling, and it's a huge tree, and if you hit it, it's going to be a big problem. You swerve to avoid the tree, and you strike the car in the lane next to you. You acted in a sudden emergency. And if you'd hit the tree, it would have been catastrophic, that sort of thing. This also applies to animal situations where, somebody had an animal, and the animal got loose or whatever, and it came out in front of your vehicle, that kind of thing. So that's called unavoidable accident. Now, the next one, I think everybody's heard situations like this. It's called, this is another rule of non-liability, new or intervening cause. Its traditional name was superseding and intervening causation. Let's say that somebody is injured in a car wreck. It's determined by the emergency response people that they need to be transported to a hospital to see how serious their injuries are in an emergency room. Then the ambulance is in an accident. Yeah, you talk about bad luck. So now the problem is, what injuries came from what accident, you see? The person who initially caused the injury is going to say, hey, this wasn't serious enough to cause all those injuries. There's superseding and intervening causation here. Oh, these cases can be a mess sometimes. Really can be a mess. Then another rule of non-liability is referred to as sole proximate cause. Now, I will tell you, as a rule, there can be more than one proximate cause of an event. In other words, that's why sometimes there are multiple defendants, who are sued in a personal injury claim. For example, you take a construction accident. You have a general contractor. You have all these subcontractors on the premises. Let's say that you have a subcontractor, and that subcontractor is negligent and injures an employee on the premises. Well, you could sue that subcontractor, but you might also sue the general contractor, who is normally generally responsible for safety on the job, for not doing anything about the subcontractor's careless conduct or not using proper equipment and so on and so forth. However, there are situations where someone is sued and they take the position, look, the sole proximate cause, there's only one proximate cause here, it's not me. The sole proximate cause is this other fellow. Give you an example. They have a whole area, a whole subcategory of negligence dealing with what they call premises security issues. Let's say that, again, we'll take the apartment complex example. The apartment complex has a lot of crime going on, on the premises. People being, mugged and robbed and things like this repeatedly. The apartment complex does nothing to shore up security in the common areas, and then somebody is brutally assaulted. Well, the idea is that the apartment complex was negligent in failing to provide reasonable security, and the crime was so rampant that the premises were unsafe in the common areas. Well, you know what the apartment complex is going to say? Hey, We didn't assault this person. I mean, we can't predict where crime's going to occur. The sole proximate cause of her injuries was the conduct of the criminal. That's an example of sole proximate cause. So, in personal injury law, you not only have to establish liability, but you also may be fighting defenses or rules of non-liability asserted by the defendant. Now, let's talk about how negligence differs from intentional torts. First of all, each intentional tort has its own elements. So, for example, the elements of trespass to land are different from the elements of assault. They're different elements. All negligence claims have the same elements, the 6 elements that we discussed earlier. There's another difference. Most negligence cases are, if there's insurance, it covers negligence. Whether you have homeowners insurance and there's some negligence that occurs, or whether or not it's motor vehicle insurance and so forth. In intentional torts, that oftentimes insurance doesn't cover it. In other words, it just doesn't cover, in many instances, intentional misconduct. Another difference has to do with a very important rule we're going to talk about now. And it goes like this. Let's say that ABC Plumbing has a truck out on the road, making calls on customers. You're sitting at a red light and that truck, bam, hits you in the rear hard, hurts you, damages your vehicle, all this sort of thing. Well, I know what you're going to say. Well, the company's responsible. Well, what if the company could prove that they had cleared their drivers? They made sure that they had very, very good driving records. They gave them the company gave them additional driver training. The company drug tested them all the time. That they monitored the status of their license to see if they got had any speeding tickets or anything that would be a violation. And this person had no violation. Well, what you'd say is, so what? I mean, it was him, he was in the company truck and so on and so forth. Well, you're close in your analysis, but the reason is a rule that's called respondeat superior. Sometimes liability can be derivative. In other words, you might be held liable for someone else's conduct. In the law of employment, the employer controls the details of the work. The employer tells you, whether or not you're supposed to wear a uniform, what equipment you're supposed to use, where you're supposed to go and do your work, this sort of thing. And because of the degree of control that's exercised over employees, there is a rule that says if an employee is negligent in the course of their employment, in other words, they're doing the employer's bidding, then if there's negligence that causes injury, the employer will be held liable. It does not typically apply, though, to intentional torts. So this rule, respondeat superior, actually goes back to the Roman era. It's a long-standing rule. And so, at any rate, that's a big feature. Companies get liability policies. Those liability policies cover negligent conduct of employees in the course and scope of their employment. Now, negligence is a broad area. So there are many, many kinds of negligence matters. Let me give you a number of them. There's aviation negligence dealing with injuries in plane crashes. That's an area of negligence. Of course, you have motor vehicle negligence. You have professional negligence. This is sometimes called malpractice. You have medical malpractice, legal malpractice, accounting malpractice, architecture malpractice. In other words, where someone has a specific responsibility professionally, and they fall below the standard of that's expected in the profession or industry. You can have liability there. So you have that, what they call professional liability or malpractice, that sort of thing. You have what is called premises liability, and these include, for example, any situation where the premises is because of some defect causes injury. Now, there's a lot of technical rules on this. For example, one of your most common premises liability claim is the slip and fall. Someone goes in a store and they step on something slippery and they have a fall. These can be very difficult cases to prove because you have to have proof that the premises owner had notice of the dangerous condition and time to correct it most of the time. So those can be tough claims. But premises liability cases deals with it arises out of the conditions of land. You have maritime personal injury. This deals with injuries occurring to crew members on vessels in navigable waters. And that includes oil rigs, offshore oil rigs. Now, there are federal laws dealing with this primarily. So you have federal statutes that create basically statutory torts, but they're based on negligence. So you have the whole maritime area. You have railroad negligence cases. There's a variety. Again, some of that is controlled by statute, but it involves negligence with respect to railroads. And I mentioned before you have governmental negligence, which is a statutory tort. So it's a very broad area, and that's the reason your most common personal injury claim is negligence. Well, I'm going to stop here, and for those of you who are students of the personal injury course, what you need to do is you need to go and get on Westlaw and see if you can find cases that deal with areas I've mentioned, that discuss the legal duty issues and things like that, and as well to look up these defenses and rules of non-liability and see what the Texas courts, if you're a Texas student, has to say about those. So that'll conclude this lecture. Thank you.